Our next speaker is Merete Smith. She is the Chief Executive of the Norwegian Bar Association, and she has been so for 9 years. She came to the Bar Association from a position as Appeals Court Justice in Oslo. She's also worked for many years at the Ministry of Justice. She's been a deputy judge and also a judge at Kvittel Dobbelt, a very famous Norwegian question program. Her presentation is called Lawyers' Duty of Confidentiality and New Ethical Questions. And this is, as you know, a topic that has been touched upon several times today already. So it will be interesting to hear it from Ms. Smith's perspective. Ms. Smith, please.
Thank you very much for inviting me here. I had a difficult task of trying to explain to you why confidentiality in certain aspects is a good idea, even though the buzzword for this conference is transparency. But first, a few words about the Norwegian Bar Association, where I work in my ordinary life. It is the representative organization for lawyers in Norway, and different from most bar associations in the world, we do not have a mandatory membership, but we do have about 8,000 members, and more than 90% of the lawyers in Norway are members of my organization. And the Norwegian Bar Association has 4 main objectives, and they are to promote the rule of law and the principles of a state governed by law, to develop the code of conduct for lawyers, and I think I will talk a bit about this, quite a bit about this today, and to administrate the lawyers' disciplinary board, to ensure good framework conditions for lawyers, and to serve the members through counseling and membership benefits. In the following, I will give a presentation of what the duty of confidentiality for lawyers actually is, how it works, and share some ideas on how it should be dealt with when balancing the importance of confidentiality on the one hand and the need for transparency on the other. And let me start with the rationale or the reasons behind the principle of lawyers' confidentiality. First, it's very important, to realize that the confidentiality and the lawyer's confidentiality is one important interest of rule of law in a state. And of course there are other conflicting interests, very important interests as transparency is, and also the need to disclose information. And I think very much of what I will talk about today is to find a balance. How do we find a balance, and what is the right balance? And the rationale behind the lawyer's duty of confidence. But in order to have a meaningful discussion of the duty on confidentiality, we need to agree that lawyers are important. Probably I will lose some of you already here. But for the rest of you, to me it is essential that we appreciate that lawyers play an important role for all those persons and businesses that is in doubt of their legal rights and obligations, and who therefore need expert legal advice. This is important in very many different situations. A person and corporation regularly needs to make plans for his or her business to make it in compliance with the legal framework, a framework that continuously grows more and more complex. Or in other situations, the client is afraid that the law has been violated, either by the client. Either the client may be the victim of such a violation, or the client may be the alleged violator. In all these different situations, The profession that offers advice to persons and businesses about the legal situation and implications are first and foremost the legal profession. Lawyers are also the persons or are the persons or businesses trusted advocate in disputes, which may often be in a conflict with the government or the prosecution authority. To be able to give the client the right legal advice, the lawyer must know all the facts of the case. The lawyer's advice may only be correct if he is able to see the whole picture, although we learned today that it's not possible to get the whole picture, including all the positive and the negative aspects of the client's situation. Only then may the lawyer fulfill his role as legal advisor to the client. The duty of confidentiality of lawyers, clergymen of the church, doctors and psychologists all share an important objective: that people may seek professional treatment, assistance or advice without fearing that the information they provide will be passed on to others. Only when the person seeking help may tell the truth free of risks, the priest, doctor or lawyer will get a sound foundation for his or her assessment. The doctor may only then diagnose correctly, and the lawyer may only then give the correct legal advice. The duty of confidentiality is a necessary tool for a lawyer to be able to get access to all the relevant facts of the case. And the client must be confident that the information he provides to the lawyer will remain with the lawyer and not brought to outsiders. The rules of confidentiality can be hard to understand. Why does the lawyer need to get information that cannot withstand the light of day to provide accurate and complete legal advice? The ideal client has in all matters acted rightly and morally impeccable. However, in a lawyer's everyday life, the case is often that the client himself has created a problem. The facts of the case are complex and hard to understand, and the facts in issue are more or less stressful for the client. And it is in these cases that the persons really need a lawyer. It is when the patient is really sick that he needs a doctor. In other words, it is especially in situations where the client has a potential problem with the law that the duty of confidentiality really assumes significance as a tool for the client to obtain correct and meaningful legal advice from the lawyer. Let me give you an example. A woman came to a lawyer and her father has just passed away. She inherited his company. And he had died unexpectedly at a young age, and she wanted to go on, take over the company, get started. She started to work with the company, and she suddenly realized there are troubles here. I think maybe my father did not pay all the taxes he should. And so she came to the lawyer. And of course, the first, and that lawyer was me many years ago. And the first thing she said when she entered my office was, "Does anything I tell you, is that told to anyone else?" And I said, "No, it all remains with me unless you tell me otherwise." And we went through the books and we went through everything. And yes, it's true. There were some troubles. But I think if she had not, but we fixed most of the things, and she went on, and she's still running the company actually. But I think if she had not come to me or to another lawyer, I think in the end she would have had paid less taxes. She might have tried to fix things herself and gone on with the company, probably, having troubles and doing things the illegal way for quite some time. It is, however, important to stress that the rules of confidentiality applies only as long as the lawyer is within the scope of ordinary lawyers' work. It is not enough to put a sign on the door that says attorney and then think the rules will apply no matter what you're doing. Confidentiality applies to activity based on legal assessment and leaves out, for example, pure money transfers, financial advice, and real estate brokerage. You have to do lawyer work to fall within the confidentiality rules. But on the other hand, all types of clients are protected by the rules of confidentiality. Private persons, government entities, and business corporations. There are, for example, many difficult legal issues when one company buys another. The employees must be taken well care of according to the law. There may be competition issues and applications to the competition authority. If the company is on the stock exchange, a whole set of strict rules apply to prevent insider trading. There are pricing issues, several contracts must be drafted, etc. In many countries, and among them Norway, the client may waive the right, may waive the lawyer's obligation of confidentiality. In other jurisdictions, they may not, for example, France and Netherlands. Those countries limiting the ability to waive argue that clients frequently cannot properly assess the consequences of a waiver. There are also other reasons for having confidentiality. The duty of confidentiality also protects the client's privacy rights. Personal and sensitive information is, as we are aware of, subject to safeguard in legislation. The lawyer's confidentiality is in harmony with those rules. When understanding the function of the lawyer's confidentiality, it is important to bear in mind that the confidentiality also have a broader impact in addition to protect client's interest. When the lawyer is able to give the client correct advice, the client will comply with the law. The rights and duties passed and sanctioned by legislators are, in other words, supported by the confidentiality. It must also be appreciated that lawyers have an ethical and legal duty to advise the client to comply with the laws of the country. If the client does not follow the advice, but chooses to act unlawfully, the lawyer must withdraw from the case, or the assignment. And of course, under no circumstances should the lawyer provide the client any help in committing such actions. It has been argued that lawyers too often push the limits of the law on behalf of the client. Well, most of us do take the maximum number of wine bottles through the customs when we have been abroad. And often the difference of arranging the investments of the client's company so that the tax burden becomes as small as possible, but still within the boundaries of the law, makes a difference between a profit or a deficit. I think the problem is somewhat else. Some lawyers push the facts. By that I mean twist the facts. An officer at the tax authority told me that for some lawyers, they always have to ask them for documentation for the facts that they present to the tax authority on behalf of the client. While for other lawyers, they have learned that they can rely on the facts presented in the cases. I wish all my members were in the latter category. That, you could always trust the facts that they are presenting of the case. Lastly, The confidentiality improves the opportunities to present all relevant aspects of a case before the court. When the lawyer knows all the facts of the case, he is enabled to fulfill the statutory duty of acting truthfully towards the court. Through these sets of rules combined with the adversarial principle, the principle of hearing both sides of the case, the judge can reach a decision being well informed of the case. This improves the possibility to reach a correct ruling. The duty of confidentiality is an important part of rule of law. And also, as the Secretary of State mentioned this morning, the European Human Rights Convention also has also safeguard the duty of confidentiality of lawyers. But how does the duty of confidentiality work? What kind of information is covered by the duty of confidentiality, and what issues does it bring along? The regulation of lawyers' confidentiality differs slightly from jurisdiction to jurisdiction. But at the bottom line, the rules are very much the same in most countries. This morning, the Secretary of State said that the Norwegian rules concerning some aspect of confidentiality was unacceptable to the Finance Ministry. And I think if that means that most countries have rules of confidentiality that is unacceptable to the Norwegian Ministry of Finance. So I'll be very interested to hear what the suggestions for new regulation that he talked about this morning actually will be. And also the Secretary of State this morning, he gave sort of a brief introduction to the Norwegian rules of confidentiality, and so I will not bore you with the details regarding the scope of lawyers' confidentiality. And I think as a general rule you can say that what it means is that lawyers must keep secret all the information that the lawyer has received in the course of duty on behalf of a client, as long as the information is not already generally known. So it must be a secret, and it must be entrusted to the lawyer, and it must be entrusted to the lawyer in the course of duty. That means it must be entrusted in the lawyer when he's doing his lawyer's work. And in reality, the duty of confidentiality covers a wide spectrum of information. Many occupations have a duty of confidentiality, but the scope differs. Real estate brokers, employees in insurance companies, auditors and civil servants are all examples of occupations that are subject to duty of confidentiality. However, these kind of duty of confidentiality are in Norwegian legislation given a more narrow scope than the rules for lawyers. The duty of confidentiality for lawyers is similar to the ones of doctors and priests, as I already mentioned. In fact, the duty of confidentiality of doctors and priests are regulated in the same provision in the Penal Code in Norway. I mean, all these three are in the same Penal Code provision. Breaches of confidentiality may be punished with up to 6 months imprisonment. For the purpose of effective administration of society, and particularly relevant to this seminar, the purpose of effective collection of taxes, there are several statutory provisions that give public authorities the right to demand access to information held by persons and companies, as the State Secretary talked about this morning. And for the tax authorities, it could also be an advantage to have the opportunity to compare their own information on a taxpayer with information that third party possesses. And then comes the question: to what extent can public authorities demand access to correspondence between attorney and the client? And here you have the collision between the right to confidentiality on the one hand and the duty to disclose information to public authorities on the other. Where do we hit the balance? The last years there have been several cases before the Norwegian Supreme Court regarding these issues. And the Supreme Court has ruled that the obligation of disclosure to public bodies must yield to the duty of the lawyer's confidentiality, and hence the issues that was brought up this morning, and the reason that the Ministry of Finance now want to have to narrow the scope of lawyers' confidentiality in Norway. And this takes me over to the ethical questions regarding the relationship between lawyers' duty of confidentiality on the one hand and the need for society to have efficient tools in fighting tax evasion, corruption and economic crime on the other hand. In Norway, public entities and especially tax authorities do actually have extensive powers to demand the disclosure of documentation and other evidence. Also, mostly from the taxpayer himself or herself, but also from third parties. The purpose of these rules is, of course, disclosure, not to undermine confidentiality, but to fight serious crime. Organized crimes in the form of terror, economic crime, and corruption is ultimately an attack on democracy and the welfare state. The fight against these threats is extremely important, and that's why we're all here. And I do not at all underestimate the seriousness of these kinds of crime. And I believe the reason why I'm asked to speak here today is that lawyers often play an important part in financial transactions. They possess the legal expertise necessary to make deals successful. They are aware of tax advantages and are often capable negotiators. And I am afraid that lawyers sometimes also may be involved in transactions involving proceeds of crime, money laundering, corruption, and tax evasion. And to make it clear, to the extent lawyers are aware of such circumstances, they are accomplices, and of course acting very far away from the role as a lawyer. This is criminal activity that I indeed hope is detected and prosecuted. And how can we supply the battle of economic crime with better tools? And I think the question is, how can we catch the bad lawyers without introducing rules that is a threat to all the members of the profession and does not treat all the members of the profession as criminals? And let me then first say something about the tools that already exist in the Norwegian legislation. A decade ago, anti-money laundering legislation that includes lawyers came into force. We already heard something about this. The purpose of the legislation is to both prevent and detect transactions associated with proceeds of crime or associated with acts of terrorism. This regulation has two main effects on the relationship between lawyers and economic crime. First and foremost, the anti-money laundering rules prevent lawyers from entering into relationship with clients with criminal intent. The regulation imposes lawyers to do a thorough client due diligence. Who is the client really? By detecting who the client is and who the beneficial owner of the client is, lawyers can more easily assess the risks of whether the potential client has to do with economic crime. If the client due diligence leads to information that links the potential client to criminal activity, or the due diligence cannot be carried out properly, serious lawyers will not take the case. Secondly, the anti-money laundering regulation instructs lawyers to file reports without, about suspicious transaction to the police. The introduction of this rule met resistance from the legal profession worldwide. The bar associations all over the world have argued that the duty to file reports on clients is incompatible with the ethic of lawyers. Many jurisdictions, including the United States, are still unwilling to, what they say, dilute the rules of confidentiality or the legal professional privilege, which is the common law term of confidentiality. In some countries, lawsuits have been filed contesting the anti-money laundering regulations application on lawyers. It is ruled that the reporting duty is unconstitutional in Canada, and constitutional courts in Belgium and France have set aside parts of the regulations application on lawyers. In Norway, similar lawsuits have, as far as I know, not been filed. And I think the Norwegian lawyers now have come to terms with the obligation under the anti-money laundering, it's a very difficult name, regulations. Especially do they realize that the legislation regarding identification of the client is a relevant tool in preventing getting clients they do not want to serve. Critics claim, however, that lawyers do not fulfill their obligation to report suspicious transactions, that lawyers are under-reporting. I do not think these assertions are based on facts. It is true that the number of reports is only a couple of handful a year in Norway, which corresponds with the number of many other countries. But it is important to understand that lawyers is the only profession comprised by the anti-money laundering regulation having exemption from the reporting duty for their core activities. The lawyer is namely exempted regarding information obtained in connection with work on ascertaining the legal status of a client and on information obtained before, during, or after judicial proceedings. So if you're giving legal advice, or if you are in a case before the court, if you get information in these two positions, the lawyer has no duty to report. And this is in compliance with the EU directive. I would also like to add that another reason for the number of reports is that lawyer avoids taking on assignment when they suspect that it has connection with criminal activity. And also, let me here give you an example from my practice. One of the first weeks I was a lawyer, and I had a businessman coming to me. And I didn't feel very comfortable with him, but I wasn't sure if it was okay just to say no. So I asked one of my colleagues, what do I do? And he said, well, you can try to ask him to pay a very large sum of money up front. That usually, makes them, find another lawyer. And I did. And then next day, he showed up with all the money in his briefcase. And then, of course, I had to say, I'm sorry, you have to find another lawyer. But this shows that, very often the lawyers, they never get as far as to take on a case. And I think maybe this is also, I think what you mentioned, that many of the lawyers you wrote to, they never answered. And I think that's what they do. They don't get in touch with you. They don't want to have you as a client. So I believe that the anti-money laundering regulation actually, to a large extent, has achieved its main goal regarding lawyers, making lawyers less attractive as tools for conducting economic crimes. I know that the Secretary of State this morning said it is otherwise, but I really do think that anti-money laundering regulation, it has had an effect. And I think also, I really do think that the lawyers has come to terms with it, at least to a large extent. Another tool, to put it that way, that we already have in force in Norway is that under Norwegian law, lawyers that are suspected of being accomplices with the client can be subject to seizure of client-lawyer correspondence. Here the duty of confidentiality has been set aside to solve crimes where client and lawyer conspire in crime. I believe this is a sound arrangement. But while saying this, I must mention that it is not without problems. We see sometimes that the police charge lawyers of crime together with the client. Then they enter the lawyer's offices and seize documents. Soon afterwards, the charges are dropped. It leaves an impression that the police pushes the limits of the law or even cross the line in order to achieve seizure of a seizure order that in reality conflicts with the rules of confidentiality. In Sweden, not even these situations permit seizure. From a ruling of the Swedish Supreme Court 2 years ago, the Swedish judges based their decision on the fact that the prohibition against seizure exists in the interest of the client. And this particularly applies when the client is suspected for criminal activities. Due to this, the prohibition cannot be set aside when the lawyer himself is a suspect. In the ruling, one of the judges wrote that, unfortunately, a criminal lawyer may make use of the client's right of confidentiality, but this is the price one must pay to maintain the important principle of the rule of law. I have heard people claim that lawyers' ethics is deteriorating. I am not so sure. I think development has been the same as for the rest of us. But there are more lawyers now. The society has become more complex, the wealth of the population has increased, and marriages do not last a lifetime anymore. Maybe the temptations are also increasing. What can we do? In general terms, I think one possibility is to make it more difficult to become a lawyer and easier to lose your license as a lawyer. And of course, lawyers that are found guilty of crime must be disbarred. This maybe sounds a very too simple solution, but I actually do think that that is one tool, one thing we can do. Also, legal ethics should become a more important part of the legal education. My experience is that what you learn early on is formative. And I definitely see from the cases we have before the disciplinary board that young lawyers who has worked for a lawyer, for an older lawyer, with many convictions in our disciplinary board, also becomes a frequent visitor of our disciplinary board. And then coming on to the financial sector, it is a fact that lawyers facilitate international transactions and the formation of shell companies. This is in itself, of course, not illegal. Critics of lawyers' confidentiality claim that it is not only the lawyer's legal expertise that makes them an attractive advisor, but also the fact that they have a duty of confidentiality. It is said that the confidentiality adds an extra layer of security to the plot, in addition to secrecy characterizing the tax havens, making the plot even harder to unveil. One thing should be done to make the lawyer's client's account less tempting for those who want to launder money, and that is to introduce a duty to disclose the name of the client to the bank in connection with money transfers to and out, to outside of the country and back into Norway. And maybe we should also make the lawyers have a duty to put the name of the clients more often when they use the client account. And as I've said earlier, I am aware that it does happen that lawyers are involved in transactions involving proceeds of crime and money laundering. And in the debate, I think the argument for disclosure, transparency and control seem to very easily triumph over the duty of confidentiality without too many objections. And sometimes I feel that in conferences like this, people speak, they talk about why, many speakers about why confidentiality is a bad idea, and then I'm the only one who's talking about why it could be a good idea sometimes. I'm afraid that if we limit the lawyer's duty of confidentiality too much, clients will start holding back half the truth or quite simply desist from seeking legal advice. This is not the way we ensure more law-abiding behavior in our society. It would rather lead to the opposite, I think, less law-abiding behavior. Another oddity that would come out of this is that the information that lawyers may hold today, and that is interesting for the tax authority and the police, will no longer reach the lawyer, because the lawyer cannot be trusted anymore. Thus, I am afraid opening up the client files would be close to pointless and too dearly bought. I agree with those who argue that you will probably catch more criminals and perhaps also prevent some crimes if you allow the police to enter the files of an attorney office. But I think you overestimate how many you will catch. And I strongly believe that you underestimate the consequences of such legislation and the negative impact it will have on society. To strike the right balance between opposing principles, confidentiality and duty to disclose, both with good rationale behind it. That is exactly what makes a sound democratic society governed by the rule of law. The right balance is not always easy to find. But I am sure that society needs competent lawyers, and that the client need confidentiality in order to receive the good legal advice. But it is to find the right balance. And I think in the end, it is really a matter of choice. What kind of society do we want to live in? And I think I'll end here, but before I do that, I was coming over here. I came over the mountains, and 2 days ago, I was doing this. And so if you have some more time, for some of you, all of you who come from abroad, only 2 hours away from here, it's very nice skiing conditions. But anyway, thank you.